4, 3, 2, 1.
Ms. Lindsay?
This Honorable Court of Appeals is now in session.
Thank you, Ms. Lindsay. And on behalf of Judge Bennett and Judge McBrayer, we're pleased to welcome Ms. Harper and Mr. Mayer to this oral argument, which is being live streamed over YouTube for the purpose of fulfilling our obligations to hold open court proceedings. Each of you has 15 minutes to present your argument. And Ms. Harper, you as the appellant have the right to reserve up to 5 of those minutes if you wish, so that you can respond to rebut what Mr. Mayer says. And Ms. Harper, do you have any questions before we begin?
Yeah.
Okay, then Ms. Lindsay, would you call the case?
Brenda S. Harper versus William H. Harper.
All right, Ms. Harper, we are willing to hear from you, whatever you wish to say in support of your appeal. The 3 judges, we are all ears.
All right. The trial court adopted something that was in 2008. My divorce was in 2003. It was an absolute divorce. Come back in 2005, they awarded William 10% of the disability. And then now on top of that, they awarded him 10% and additional 10% of the gross pay. I've been fighting in the court for them just to honor what they had said in the divorce decree. It won't work. I've been trying now to give y'all a withdrawal. I didn't want y'all to think I was playing, so I had to get on. I was trying to tell you that whenever you said that I wanted to say something. They're unilaterally changing CRDP and CRSC. Whatever the disability is, they're taking it, they're saying, okay, if the disability is 800, the CRDP and the CRSC, they're changing it so they can have that money put back in. Is going as a separate check and not in as retirement, therefore still reducing my portion of my retirement.
Yes, ma'am. Take your time.
Awarded me 50% of his retirement. It's an absolute. I didn't know the law. I don't know the law. Lawyer and I went back in and they gave him 10%. He had to still pay the difference. He stopped doing it. Every time I went back in the court to try to get them to understand what the divorce decree said, he never honored it. And then in 2000, I think 17 or 18, he ended up saying that I guess the divorce was now and void or partial now and void, which gave me nothing. I'm asking the court to just honor the divorce decree. They say 50%. We went back in the court in 2005. The judge said the only portion of that retirement in which I could not touch was a 10%. Since that time, he's went up and disability, but yet he refuses to give me any monies. The difference of it. All I'm asking is that if that is void, then I should at least seek alimony. Mr. Maher is saying I can't. He's saying that I cannot seek alimony because it's barred or something. I'm saying, if it's anything, Mr. Harper should have said something at the thing whenever he said that my disability might go up. So their honor, you need to give me 20% or 30%. Instead, he didn't. Mr. Maher tried to say that he even had 20% when he only had 10%. That's when the judge said it was duly noted. I'm here today pleading with the Court of Appeals on my behalf.
Now, Ms. Harper has
revisit the divorce decree.
Ms. Harper, you and your ex-husband were involved in an appeal that came before this court a few years back, and it appeared to be on a very similar, if not the same, issue. Is that correct?
Yes, sir. What happened was in 2004, we got my divorce in 2003. He was supposed to give me the monies. He didn't give me the monies until 2 years later, and that's when I noticed Mr. Maher came on the scene. He wasn't there in the courtroom. I asked the judge for alimony. The judge said that 50% of William's retirement was enough. I have a divorce decree we signed saying that I get 50% of his retirement. It was just on paper. It was never, the judge saw it, but then he said he was going to rule his own ruling. I have it right here. And we signed it so I could receive the 50% of his 50% of his retirement.
Didn't Judge Dinkins of this court, along with two other judges, write an opinion a few years ago that dealt with this issue about the disability and the fact that the federal government says that the courts cannot take a disability benefit away? And if they do, they were without authority.
That's without authority. But at the time of my divorce, it was already done. It was an absolute, it was already done. Mr. Harper never even mentioned, oh, I have a disability. He never even mentioned that. He could have, whenever we signed this, he could have said, oh, judge, let me tell you, I have 10%. He never did. I didn't find that out till 2005. But I did go before the court, Your Honor. I tried to get the coppers off in order for me to get the appeal going through. What happened, Judge Jones decided that I had $12,000, but William wouldn't give it to me. He wouldn't give it to me until like a year and something later. Therefore, I couldn't even do it. I haven't struggled. I struggled. But now what they're doing is that they're unilaterally changing the CRDP, which is a government in which they can go ahead and even take out even more. You have to ask for it. But the courts are not even looking at that when it comes down to spousal support or spouse having any of the form of retirement. Eventually, retirement is just going to go away. I don't even know when it's going to go away. It's a scary feeling because
well, I can understand why
he's successful, got all the money, and he's going to get it all. What did I get out of the divorce, Your Honor? What? I mean, it's a piece of paper. It said the court should determine that Mrs. Harper has also had a vested interest in the military retirement. Mr. Harper, dating back to the entry of the final decree, Mrs. Harper was awarded 50% of Mr. Harper's retirement. His decision to waive a portion of that disability pay, whether it be before or after the final divorce decree, should not serve to strip Ms. Harper her vested interest. You're going to strip me. Additionally, Mr. Harper already waived 10% of his military retirement to receive it. How he did it, went back into the court. I didn't know what else to do, but I wanted to be fair. If he had the 10%, the judge said that 10% was the only thing that I could not divide up. Later on, they just went on and on and on. Now here we are. I'm trying to represent myself. Mr. Maher, no, I don't live lavishly. I'm living in. I need for the court to rule in my favor.
All right.
Have it. I don't have much. They got even with Johnson and Johnson. Considering the trial court determined it was necessary to modify the final decree, they need to modify it for me.
All right. Well, let's do this. Let's save some time for you to respond to Mr. Mayor. So argument, if that's all right with you, and we'll hear back from you in a minute. Is that okay, Ms. Harper?
Yes.
Okay. Mr. Mayor, we'll hear from you.
Yes, Your Honor. Thank you. As the court rightly noted, we were back here in 2014. We argued essentially the same issues before the court, whether they had authority to modify the decree back in 2005. And I think that's the important thing, at least one of the most important things. We argued that in the last case too. This order went down in 2005. And I think even Ms. Harper in her brief on page 17 rightfully argues that the court, if it had the authority to do it, should have gone back after that 2005 order and modified it. That would have been the time to appeal, saying if the court's going to go back and modify this to take away the portion of disability that was awarded at the divorce decree, which it rightfully did under the state of the law at the time, that would have been the time for her to appeal and say the court doesn't have authority to do that. And she does note that specifically in her brief. And basically she argues the same arguments in 2014 as she does here today, that Johnson versus Johnson in that case. Of course, Johnson was still upheld until eventually the progeny of all these cases worked their way to the Supreme Court, and Manziel, which was pre-divorce 1989 case, was upheld in Howe v. Howe. United States Supreme Court basically said the courts don't have the authority to do this. They don't have the authority to provide it under any circumstance.
Mr. Mayor, aside from these court cases, is Ms. Harper receiving any benefits from the 2003 divorce presently today?
She was receiving her portion of the non-disability rated. I don't know at this time whether that's been reclassed as CRSC, but she was receiving those benefits. The only thing she was receiving from my client was the 10%. The rest of her money was coming directly from the military, and so that was the always a small portion that she was getting from my client was just a 10%.
But she is receiving the benefits or some of the benefits directly from the military.
Is my understanding at the time of the last hearing, yes, she was.
And what's in dispute is the portion that the ex-husband is supposed to be remitting out of the other portion, that part of which is the disability, and that's the exempt part.
Correct. In the former case law under Johnson versus Johnson, the court said that it believed that had that vested interest, that of course Howe came back in 2017 and overruled. So that's what she received from my client, and that was what is the issue in the case back in 2005 when we filed our Rule 60 motion under Manziel. That's what the issue was in 2014 when she, after multiple motions, tried to appeal that order, and then the court found that one wasn't timely filed as well back in 2014 because again she was time barred because the originating orders back in 2005 and all this appeal should have been done. And then this appeal comes out of 2000 in 2018. The court put down an order saying yes, he does not require to pay this under the VLATS decision. That order making him pay that 10% to her directly is null and void. Then she filed a Rule 60 motion after that, and then the court, as she properly notes in her brief again, I think she notes it on page 14 of her brief, that the court later clarified that October 11, 2018 order after she filed several motions, which in the old days we used to call those motions to reconsider, but they don't exist anymore because they don't stop your time frame for filing appeal. But she filed a motion after that, and then back in February 11, 2020, which is the order she says she's appealing now, it again clarified that the court's position was correct in finding that order was null and void. And then she went on to make the argument before both those hearings that the court couldn't just set aside that 10%. It just had to set aside the whole divorce and start all over. And the court said, no, that's not true. It wasn't true in 2005 when the original order was done. It wasn't done true in 2014 when you tried to revisit this in 2013. And it's not true in 2018 when we again followed the same procedure and determined that it was not, didn't set aside the entire divorce decree and could be properly sectioned out from the rest of the divorce decree. And so we think based on all that, again, since this is another same case we've had to go forward on, that's years after the original order. At this point, it's frivolous. She states case law from Johnson & Johnson, which is no longer any good. And she even in her own brief argues that the 2000 is properly, what all used today, probably should have been brought after the 2005, that's when the court could reopen and determine whether any alimony is necessary.
And so under the marital dissolution agreement, divided the military retirement pay 50-50, correct?
There was, the NDA was actually never entered. They went to a trial and the court enforced the NDA that they had previously signed, the terms of the NDA. So the specific NDA itself was never entered. Mrs. Harper objected before that was entered in the court, asked to have it set aside. They went forward and had a trial on the merits, and the court determined to enforce most of the provisions of that NDA in its final decree of divorce. So
it wasn't a matter of agreement, but what the court initially ordered back in 2004 was a 50-50 split of military retirement pay.
Correct.
And then on top of that, the court ordered Mr. Harper to pay 10% of his disability pay.
No, after Mr. Harper got the final order, another attorney discussed the military aspect of that under Manziel with me. I took the case, filed a Rule 60 motion to set aside that
based on Manziel.
Based on Manziel, yes.
Yeah. Okay. All right. And then the U.S. Supreme Court just basically re-upped it in how and said, really, we mean what we said in Manziel, basically.
Yes, Your Honor.
Okay.
And so that's been our position the whole time since 2005. And like I said, this has been multiple motions have been filed, reheard.
Yeah, let me ask you about the procedural posture too, because one of the points you make in your brief is whether or not we should consider this appeal timely at all. There was a petition to enforce, I guess, the original decree of divorce, and then there was this subsequently filed Rule 60 amended petition, correct?
Yes.
Okay. And then I saw in the original record where the court denied the Rule 60 relief. Is there a separate order in there somewhere disposing of the petition to enforce?
I think it's just all came down in the October 11, 2018 order where the court just said that the provision was null and void, and that's how they handled that. And then the Rule 60 motion, all the brief was filed, and her Rule 60 motion, the brief was filed, but it was never proceeded on. And then they filed an amended one after the 2018, October 2018. They filed an amended one with the proposition that since the court did not have authority to segregate out and say that no division of military retirement can be made without setting aside the entire decree. And that was the Rule 60 motion that was then denied in February 11, 2020. The court again said that they were proper and found that was null and void, and it did not require the entire judgment being set aside.
Okay.
So,
All right, Mr. Mayor, anything else?
That's all I have, Your Honor.
All right, Miss Lindsay, would you put 5 minutes on the clock for Miss Harper to provide her rebuttal? Miss Harper, you have the floor.
right, all I'm saying is that the divorce decree, if you change it at all, you should look at changing it for me too. Mr. Maher is sitting up here telling you, I tried, Your Honor. You go back, you can see in the appeals, I tried. Judge Jones wouldn't let me go ahead and do the appeal on the pauper's oath. I asked him, I said, Judge, he wouldn't listen. He said, well, you got $12,000 from your ex. He never gave it to me until Maher came on the scene. He never gave it to me. Otherwise, I could have done it. My lawyer that was once who was there for the divorce didn't say anything. He said the judge told him, don't say nothing. Didn't say anything. Later on, he passed away. Then they said that they closed all his files. I never even got another lawyer in order for them to get the cases from the lawyer that I had, Mr. Bush. He died. He was sick. He was bleeding in the office before we even came to court. Judge wouldn't let me speak. Then they try to make it sound like I was married to this man for 22 years. They made it sound like I was in the courtroom for only 20 minutes. It was physically and mentally abusive to me.
Was your ex-husband in the military the entire time of your marriage?
Yes.
Okay.
And the hard part about this is that I didn't want to do anything wrong. I looked at his LES, it said 10%. I was just doing right by what the court said. The court said, hey, he got 10%. Nobody never came to me and said, look, you need to appeal this. Nobody said any of that stuff to me. Not only that, the divorce decree, I didn't get it until it was signed. I didn't even know what was on it until it was signed. Some of it was because Mr. Bush, I couldn't get in contact with him anymore. You can ask Kevin Kennedy. You can ask Ed Crozier. They seen a sign for the 50%. If you're gonna do something different to him, you ought to look at it and look at the whole and say, okay, well then Ms. Harper needs to be awarded alimony, some portion of it, because right now what they're doing is that they're unilaterally changing it to CRDP, which is a government, not the VA. So his portion is continuing to go down. Mr. Maher knows this. It's either going to be in CRSC or CRDP. Y'all don't realize when William came back from Saudi, he wasn't the only one. We had to get a physical in order for him to get out. In that physical, it showed we had the same things that were happening to him was happening to me and my daughter. They had to remove things surgically from her skin. Mr. Maher won't tell you that. When I tried to go back to the army to get the copy, they said it was under lock and key. You would see we had the same rashes. It was burning sensation. When he had sex with me, it was burning. I'm probably not the only one that's going to tell you this, Judge. All I'm saying is that it's going to be reduced down to nothing. I had turned in my withdrawal. It was too late. I didn't want to feel like not showing. I should have something. Right now, they're going to window it down to nothing. I would love for the courts to consider it. Consider how recognizes divorce parties. I was entitled to something. After this divorce, I will get nothing. Literally nothing. I walk away with half the stuff that he didn't go up in this house, from tables to coffee tables. Don't live lavishly. Just wanted it to be fair. For people now that have been married for 8 years, alimony. The judge told me 50% was enough. Alimony. If I had known, I would have tried to do alimony instead of trying to get 50% of his retirement if they could do this. Please, I'm begging y'all.
All right. Thank you, Ms. Harper, for your comments and presentation. And Mr. Mayor, thank you. And we will take this matter under advisement, and a written opinion will be presented and filed with the clerk, and the clerk will forward that to you. Ms. Lindsay?
This Honorable Court of Appeals stands adjourned.
All right, thank you. And Ms. Harper and Mr. Mayor, you are free to leave the meeting. Thank you.
Thank you, Your Honor.